All right. Hi, this is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for September 29th of 2025. Got a good week here, Brad, but go ahead. Go
We
ahead,
do.
take us
The
away.
last one is the big one, right? I mean, it's like it's almost planned that way. Save it to the end. But so let's start off though in Jacksonville, where we have a firefighter who's filed an ADA claim, basically saying, let me summarize it, but it's a very appears to be a very valid suit. He says, he has a disability which makes it hard for him to read and comprehend. And so the tests he's given have to be given orally and convert, right? But that means the prep materials they were
Was
given.
was it orally? Maybe I misread that then. I
I
didn't
could be
see.
wrong. I do these
I
okay,
know
but
he wanted more time so that he could convert the written material into an audio format so he could recall it.
right.
Did he also wanted the exam in? Because
I took it as the exam prep materials
right,
have to be done right orally, but I'm assuming I guess I shouldn't, but I'm
yeah,
assuming when he gets to the test, which is not part of his claim, it
right,
could be administered orally. I
right,
assume they go hand in hand, but
yeah,
here he claims that they shortened the time by which they sent out these voluminous test materials,
mhm,
and he said he couldn't, it doesn't have long enough to convert them to a format that he could study from.
mhm.
Normally, I shouldn't say normally because I don't follow a ton of these, but normally you see the testing conditions themselves, right? You see claims about the testing conditions. You don't see claims about the preparation of materials,
Mhm.
but it would give others an unfair advantage, right? Which is grievable under the ADA. It gives others an unfair advantage, allegedly or possibly, if he can't read through those voluminous materials because of his disability and can't prepare. I mean, we could get more in depth of the facts, but
Well, I
that's
think I do want to get into this one. Only I had several people reach out to me through social media and by email saying WTF.
oh, really?
Oh yeah.
I
Oh
take that
yeah.
view.
And some of the folks are people who are studying themselves and saying, why does this guy get extra time? It's unfair to me that you're disadvantaging me.
Oh, well, that's the law. I mean,
Well, yes and no. Yes and no. I think we owe people a little bit more than we need to explain. Because in my opinion, this is going to come down to a battle of the experts. It's not going to come down to the lawyers. It's not going to come down to firefighters. And it may not even come down to fairness. It's going to come down to people with PhDs, maybe psychiatrists with MDs, stating that he can do the job. That's going to be number one. He can do the job as an officer, and that the process that they're using, does not adequately measure the types of things that he's going to have to do as an officer versus his attorney and his experts are going to say, number one, he can do the job, and you know the test that they're using doesn't measure the capabilities of somebody who's going to be an officer.
well,
So
I look at it
I
very
think,
different.
hmm?
I look at this case very differently. I look at this
That's
case.
good, and that's good. I
Oh,
think
okay.
folks will benefit from us having that
Yes,
discussion.
I hate when we agree all the time, though
Yeah.
normally we do. But I think here that it's, he says they were other candidates get 60 days to study,
Yep.
right? But he can't possibly do that because he needs these materials converted so
Mhm.
that he has a fair chance to compete and
So let me just
learn
explain
this
let
way.
me explain my life,
Sure.
okay? And I got on Providence in 1979, and shortly thereafter I started studying for promotion, even though I wasn't eligible till I had 6 years on the department. Then I went to law school and I had to kind of put studying aside. Okay, now I didn't know the material that was going to be on my exam in 1987, which is when I actually made lieutenant. But I knew what they had tested on in the past, and I was studying it. I was starting to put my material together, starting to create index cards. I had audio tapes that I had created to remind myself of certain mnemonics, certain things. So, and I wasn't the only one. I would say probably half of the folks in my academy class were doing that. Okay. And so now I finished law school, and almost like before I passed the bar, pretty much I studied, but I was also starting to put things together for promotion. So for somebody to say, "Oh, I only had 30 days," I'm not buying. Now, some of this is
Oh,
going to be
I buy it.
some of these are going to be the qualifications or the arguments that attorneys make in the case. But if I'm representing the city, um, his attorney is going to trivialize that. The city's attorney should be arguing that our folks know what is going to be on it. Now, what we do, because some people can't handle all of that, that we do limit it on a certain exam to emphasize, like, for example, we want to emphasize high-rise operations. We had a problem a couple of years ago. This exam is going to have quite a few high-rise. So there's going to be high-rise, there's going to be maybe water supply, there's going to be accountability, there's going to be whatever the issues are that they got to focus on. But you know, I just find the argument a little disingenuous that he only had 30 days to prepare.
So here's how I look at it. I
Yep.
look at it that if the city didn't send anything out to people and said,
Yep.
go study on your own, you
Mhm.
would have the winning argument. But
Yep.
here they intentionally sent out these materials for some purpose.
Mhm.
Everybody's on equal footing except for him. He's disadvantaged because of his disability, because the materials aren't useful for him as they are with others. What
Right.
the city ultimately will do is say, we're not putting any of this out in the future. You go find it on your own, and they'll avoid having to convert everything. But I think
Yeah.
he's got a winning argument. If
Yeah.
if
No,
what he
I
said is
think so, but I think he still is going to have to prove that the accommodations that he is requesting, if allowed, would allow him to successfully serve as an officer. And the
yeah,
city is going to argue that if we granted that accommodation, we would be allowing someone who com cannot meet the essential functions of being, and I think it's a lieutenant, or lieutenant, whatever it is,
right.
lieutenant or captain, but they cannot meet the essential functions. So that's what I mean is it's going to come down to a battle of the experts here, and who the court, thinks is more credible, um, his expert or the city's expert.
Yeah, and I you look at like the essential job functions, right, which is so
Mhm.
critical in so many
Yeah,
departments. As we know, that was one of our day one of must-have policies that we put
yeah,
out. We know that so many people don't have those and haven't customized them. And we've seen cases where they said even being able to work a 24-hour shift, it could be an essential job function. But
being able to work cooperatively with your colleagues.
right. And in hazardous, hectic conditions. But here, the question is whether the ability to read large volumes of a material in 30 days is probably not in their right in their list of essential job functions. So they
Right.
can't come up with it now.
No,
They're
but the
probably
experts, the experts are going to have to look at it and then say that the accommodation would have allowed him to meet it, or it's really irrelevant. I mean,
agreed on
yeah,
that. I just think he's gonna easily prove, maybe I'm trivializing it, but that, if you sent the test out to everybody, or the prep materials out to everybody, clearly the city believed
mhm.
that they were relevant, and his inability to do what everyone else can do to prepare is a disability which could have been
Well,
accommodated.
it's a fascinating issue. There's one more issue, and then I want to get back to something else. But one more issue here has to do with whether or not the city engaged in that interactive process, and that's one of the allegations. And I think perhaps on procedurally, if the city doesn't come to the table and at least be willing to
They're in
entertain,
trouble.
they're going to lose right on that. And
Right.
that, and I think is stronger argument. Now, here's one for you. This is I had to put together a class. This was almost 10 years ago now. I had to do a class before Pro Board at the Pro Board annual conference on disabilities. And I had a passing knowledge of a lot of this stuff, but getting ready for it, there was a series of cases that talked about giving people a longer period of time. So let's say the exam is 3 hours, okay? Johnny comes in with a note and says Johnny needs extra time. You should give him one and a half time that you're going to give everybody else. So now we're going to go an hour and a half longer, so it's going to be 4.5 hours, okay?
Right.
Given it wasn't a fire department case, but a given organization said, fine, we're going to give everybody 4.5 hours. And that was discrimination. That was found to be discriminated against.
Right.
But on the other hand, I guess, how do you be fair to everybody, but still be fair to someone with a disability? That's not going to be solvable in the abstract. It's just,
No. And that is totally expert opinion based, as you
it
say.
is. It's really, and I know when I was studying, when we were studying, I mean, I studied as hard for promotion to lieutenant and captain as
You
I
did
did
for
for
the
the bar
bar.
exam.
Yeah.
Absolutely,
Yeah.
positively. And the folks who studied with me and knew how hard I was studying knew that as well. And they were studying just as hard. So this means a lot to people, and they put the time in, and then to have someone who is going to kind of want it the way they want it, because there's things I wanted to see in a promotion. I would have liked to see a harder test, but I couldn't. You can't really control that. But trying to, I don't know, shift the underlying mechanisms to make things come out the way you want, I don't know. It
Well,
causes resentment in the workplace.
the guy with a disability would say, I'll trade places with you any day. You take my
Yeah,
disability and I'll take a shorter time.
no, that's and that's the fairness counter argument. Okay, so but these arguments cause dissension in the department, and I've
But the
seen them.
bar exam
They
allows
can,
you extra time. The
yeah,
the SATs, all these testing exams allow you extra time for
right,
disabilities. So
right.
how is this one going to be any less than any other?
It's not. But when somebody gets extra time on the bar exam, they're not going to sit next to somebody in a few weeks who got a better score but didn't pass the bar. And you can see where if you put, let's say they're all in the same law firm, and now somebody's got to stay a paralegal for another year,
Right. Right.
and somebody else who got a lower grade or whatever ends up going by them, it creates resentment. And you know what our environment is like, the
Yeah.
firehouse environment. And when that happens in the firehouse, it's tough. It's tough.
Well,
And I'm not saying
just
he
like
shouldn't.
DEI, right?
I'm
Just
not
like
right. I'm not saying he shouldn't get an accommodation. It's going to be up to the experts. And again, the emails that I sent back to the folks who contacted me, I said, this is not going to come down to firefighters. It's not going to come down to lawyers. It's going to come down to the experts and whether or not the accommodation is indeed reasonable.
what they
Uh,
should have done is just delayed the exam to go back to the prior, what was it, 6 months instead of
yeah,
30-day time, right? Because he didn't complain that that was too little. He said the shortened time was too little to prepare, and the preparation issue is the rub, right?
yeah,
It's not the exam taking issue. That I don't think that's the issue here. I'm just presuming he's going to get it. But the issue is, which I think is novel. I say novel because I don't follow a ton of these disability cases
right.
like this. But I know for a fact you got to give extra time in an exam. But extra time to prepare for the exam,
Is
that's a novel spin.
Yeah, yeah. No, I agree. I agree. So
Anyway, but we will see what happens. But I got to tell you, my belief is he wins.
yeah,
I think he wins. I think they have to avoid the test and they have to give everyone the same time to prepare, or the 6 months or whatever. Okay, everyone's seen this on the news because there are certain parties that are making a big deal of it. That an Oregon firefighter was detained. He was working for a private fire service,
hmm.
right? I don't know if this is one of the rich ones, rich people hire to protect, or if it's just, but he's
No, I
hired by
think
a.
he was under his business was under contract with the U.S. Fire Service.
Oh, okay.
So
Okay.
yeah,
But the short is he had been here since he's a young child. He
right.
did have a misdemeanor conviction, I think, for speeding or something like that,
Racing,
for,
racing, yeah,
racing. And,
yeah.
but
Kid stuff.
they detain him, they release him. ICE is like, we're going to release him anyway. And look,
Hmm.
I'm not going to get into the politics of whether, we should, people who are born here, that's going to go before the U.S. Supreme Court shortly, birthright citizenship.
It's
So I'm
there.
just trying to
It's
get
there. I
your
was
vote.
listening to
Yeah.
oral arguments in it last night. Yeah.
Oh yeah, I mean we'll have a decision presumably. Well, I don't know when. I'm not going to guess, but in any event, but the whole birthright thing, I think personally think the U.S. Supreme Court is never going to overrule birthright citizenship. That would be horrible for many reasons. In any event, But that's the issue, and he's been here for a long time. And what's amazing is the lengths that ICE went to go to an active fire and find the guy. I mean, they
Yeah.
all look alike. We're all wearing yellow and green or whatever they're wearing, and to pull the guy off the fire, that was. I don't want
Yeah.
to. I don't know what term I would use.
I don't know if they went there looking for him or they just started going through people's IDs saying, "Where are your papers?" Or
But on a fire, I mean,
I know it.
Jesus,
That's
you
the
know,
incredible part. I
all
don't know. I
hands.
don't know. You don't know if they had they were tipped off about something or whatever, and whether or not, like, how did they make a mistake that this was not the guy they were looking for, with, I guess, a similar name or whatever, had been charged with some sort of drug offense or something, but it turns out he's not the guy, same
Right.
name, but I don't know. How do you not? I don't know.
Yeah. And what are
I
you
don't
gonna do? Ask for identification in the middle of the fire? So I don't have my license
Apparently
on
that's
me.
what they did.
Yeah.
I'm sure it was probably at one of the rehab centers. I can't imagine
Right.
that
They
it
went into
was
the trails and the woods.
either the
Yeah.
base or camp. Yeah.
But still crazy
Yeah.
stuff.
Uh,
Okay, so we've got a lawsuit filed in Indiana. It's a federal discrimination, and of course, with it always goes retaliation, which is just departments making something that might not be bad worse, or making something that really is bad worse by retaliating. But we have a former firefighter, and filed suit against suing the city of Fishers and the Fishers Fire Department, alleges race, sex, and disability discrimination. We see a couple of these cases where there are so many allegations, specific time, date, place, here's what was said, and quotes, that this is a jury question, not a legal question. Because if the facts are true, the city loses and is paying out the yin yang, right? But if the facts aren't true, so this is all going to be about a jury and who do you trust? Who does the jury believe? But let me read some of the things that this firefighter, Lauren Gray, who I think she was the department's first black female firefighter, right? So being the first comes, I think people realize, comes with it some challenges you face. And this is a continued to-do list of everything you never want to do, right? So they said she alleges, we don't know the facts yet. She claims they suspended her for 24 hours without pay for allegedly failing in to clock in on time by merely a few minutes, but that other non-African American males would clock in much later and have no issues. She says she was switched to a light duty administrative rate that caused her to lose 6 hours of accrued paid time, but similarly situated males were not treated that. And you're going to see that constantly, similarly situated white males, right? Because she's the only black female. Now, I don't know about black males. That's the interesting how they were treated. But she said she was scheduled for a shift, even though she had requested and was granted the day off. I mean, that shouldn't be hard to approve. I presume there's emails and things like that. Now, maybe there's a policy that allows that. I don't know, right? It just sounds bad. She was written up for not reporting to work on a certain day and then was suspended without pay. But others who had done the same thing when they had approved time off didn't get penalized. She was told not to attend her graduation ceremony because she might not pass. But others were permitted to go regardless. Claimed she was subjected to sexual harassment from coworkers. One who said, I hate even saying this, he wanted to make brown babies with her and then allegedly physically grabbed her. She reported it to HR in June of 23, but no action was taken, she claims. I mean, this just goes on. But, when you have one or two things, that's one thing. When you have a laundry list, you either start writing a check or you better be able to prove that she's making this stuff up.
mhm. Yeah, a couple of points. I mean, she was not on the job for very long. She seemed to constantly be having drama entering into, seemed like every day in the firehouse it was a different drama problem. One of the issues here, and in particular, where she talks about her being disciplined and no one else being disciplined. This is a challenge. I think when you were down in Florida and I was doing my leadership class, the leadership case studies, I mentioned, I don't know if you were there for it, but HR doctrine, Okay, folks who get degrees in HR, they have their sort of mantra, okay? And their approach to discipline is that discipline is between the employee who did something wrong and the employer, and no one else is to know about it. Okay, no one else is to know. So you can have a firefighter in the firehouse who is insubordinate to their officer in front of 20 people, and whatever happens to that firefighter,
Private,
it's private. Okay, so now
as it should be.
what happens is it looks like nothing happened.
Right. Right.
Okay. And this is where HR kind of can come back to bite us, because the person may well have been disciplined. You just don't know about it. And this creates a problem. And when a plaintiff like this goes into her attorney, she's going to say, "Oh, well, so and so did something. He never got disciplined." Well, you wouldn't know about that, would you?
Right. And that's the danger when you make claims that look good on paper.
Mhm.
If they can come back with facts and say you weren't privy to that information, now your facts are wrong, and you
Yeah.
start chiseling away.
And
But that's
what did you do to find out before you put it in a federal court pleading? What
right.
did you do to find out whether or not it was true or false? And
Yeah.
that's an obligation on her attorney as well,
Yep.
to verify that kind of stuff. Okay. But I think my lesson there is that from HR, and I try to encourage folks that are HR professionals for fire departments, is that our workplace is not like the sterile type of workplace that you were trained in.
Right.
That, in cubicle world, I think of when I worked at the NFPA, it's kind of like cubicle world. You're either in an office or a cubicle.
Right.
What happens in cubicle world can stay between the employee in the
But
cubicle
we're
and
at the
HR,
table.
right? Where everybody sees it, and when it looks like there's no consequence, this is what you get. It looks like nothing happened. So I
Right.
think some of her allegations may end up falling apart. And again, I'm suspicious when I see a lot of drama in somebody's life. I mean, anybody can have something bad happen to them, but I don't know, when you start seeing this, especially over a short period of time, like, all right.
Yeah.
So,
And how do you prove, right? So take this, I want to make black babies with you. How
well,
do you
that's
prove that's true or not?
how are the taxpayers of the city of Fisher, the town of Fisher, responsible for an inappropriate comment that a firefighter makes?
If it was made,
If it was
right?
made, right,
Who
right.
knows? Who
But let's
knows?
assume it is. Let's assume that was a truthful statement.
Right.
But how are the taxpayers responsible for that? Now, if there's an officer there and the officer didn't do something, now
Right.
we're in a different
Or if
arena.
it's an officer who made the comment, right?
Well, that's now and then
Which
that,
isn't the
yeah,
allegation.
absolutely. Yeah.
Right.
If an officer is involved in that, now we got to look at how did this person become an officer and stay an officer. This probably wasn't the only stupid comment that they made,
Right.
and so on. But certainly, so I think that I don't know, uh, if what she says is true, I think the city is going to be in trouble. I am highly suspicious that everything that she put there is true.
Right. Right. And a lot of that with light duty, with clocking in, with discipline, all these things is easily provable by the city. The problem is if what she says is right and they haven't disciplined similarly situated persons,
That's right.
now they're in trouble.
That's right.
Um, and,
Absolutely.
and they're going to figure
Absolutely.
that out right in discovery phase,
Yeah.
because they're
Yeah.
going to write subpoena, give me all the discipline here, give me all the times you did something here.
Mhm.
And boy, I hope, the city's got good records.
And it's so
Um,
important that we are consistent. And I know you probably know officers who write a lot of people up, and then you have officers who don't write a lot of people up. And neither one is really what we need. We want, folks that are exercising their discretion, in a consistent way, not just consistent, personally consistent. You treat this, everybody does something the same way, but
right.
also from officer to officer, because if not, this can be a reflection of the fact that we've got inconsistent enforcement of the rules.
And I'm thinking of something else as you're talking. I've never told anyone they should keep a discipline log of
Mm.
all discipline given to their employees,
Yeah.
right?
The
Normally,
organization should.
the organization
Yeah.
should, but I've
Right.
actually never thought about encouraging that, because
Yeah.
normally how it works is, okay, John Smith gets something in his file or did something wrong, we put something in his file, right? And okay, that's done. I didn't write on some log, I disciplined John Smith for this on my total discipline log.
Yep.
Now the problem is in many CBAs, right? We have an agreement where, okay, verbals, or proof of verbals or writtens come out of your file at some time. So
Mhm.
we destroy the record of it.
Yeah.
Well, what do you do? Because you're damned if you do, damned if you don't. You pull it out of the record, out of his record. You have no proof that you treated someone like that. If you keep it on a list, you're kind of violating your agreement in the CBA saying that you wouldn't leave it,
Mhm.
or you wouldn't make a record of
You've
it
got to
after a certain
keep
amount
it.
of
We
time.
call that a professional standards database. And in my class, we talk about the importance of having that. And not only that, we want demographics. We want demographics of the complainant. We want demographics on the witnesses and also demographics on the accused. And we've got to analyze that information because we want to make sure that we're not burdening any protected class. So we've got to periodically look at who are we disciplining, what's their demographics. No one should have to come to us and say your discipline process is burdening a certain protected class.
Right.
So we should be looking for that. And then if we start to see some statistical differences, they're getting punished more harshly or whatever. We've got to be looking at that because if we're not looking at it, you're going to find out after you get sued, and it's too late at that point to do something about it.
Yeah, and I know it's more on the HR side, but it
Mhm.
creates such a problem. What do you do with the counseling, right? A lieutenant says to one of the guys, "Hey, you shouldn't
Mhm.
do that,"
Yep.
right? And the guy's like, "Okay, great," and doesn't do that again.
Mhm.
Lieutenant says it to somebody else, and it turns into a
Yep.
written reprimand or a suspension. Well, wait a minute. It looks like we're disciplining this person, yet we told someone else not to do it. We got no proof of it. And how many times a
I,
day does that happen?
I gotcha. I gotcha. And there was a case, and I forget which. It was a big city. It was like Chicago, or it was a big Midwestern city. It probably wasn't Chicago, but it was a African American female was disciplined for coming in late, and one of the allegations in the lawsuit was she was the first firefighter in the history of the department to ever be disciplined for coming in late.
Oh,
Oh,
come on.
that's
Right,
exactly the expression on my face. Okay. But I'm thinking the department didn't have any record
right,
of it
right,
because they got rid of them all,
right.
you know? So again, it's another reason why you need to have that
Log.
database.
Yeah,
So,
and it's funny. I never thought about that to now, and I do a lot of HR manuals, and we talk about how you preserve discipline, and
yeah.
what happens when you take something out of someone's file.
Well,
But
there are some ways that you can address the union's concerns or any other concerns about maintaining that beyond the length of period. Is you just strip away any identifiers
right,
beyond demographics, the age, the rank, the race, the gender, and
yep,
protected class information, so that you can say, okay, a 35-year-old captain was disciplined on such and such a date for coming in late. First offense, here's everything,
right,
so that
right.
you still have all the key information you need to make sure there's not discrimination going on, but at the same time you're honoring your commitment to the firefighter, that
Yeah,
it's
and
not going to
I think all
stand up.
volunteer departments should do that. Career
Yeah.
departments, they all face the same types of discrimination suits. It is a brilliant idea, and otherwise, like you said, how else do you defend it?
Yeah.
So, all right. This is just one you don't want to defend. We have a
You and
four.
I talked about this,
Oh,
excuse me,
yeah,
this one. I don't know if you remember it.
yeah, I
Uh,
do. It was sick the first time, and here we
yeah.
go again.
Yeah.
So we have a former. Well, you'll know why he's former soon. A Clark County firefighter who was charged and convicted of possessing child pornography or sexually abusive material. He a phone. His phone, I think, was found having improper, illicit images of children, and it was discovered in his bunk. So he was found guilty at that time to 3 counts of possession of child sexual abuse. He was placed on probation for up to 3 years, registered as a sex offender, prohibited from having unsupervised contact with minors. Frankly, he should have no conduct with or interaction
Contact.
with minors. But nonetheless, while on probation, right? I always say nobody's a pedophile once, and
No.
nobody's an arsonist
And
once.
that's why I put this in here, because like sometimes the department goes through a process and maybe you have your suspicions about, should we have fired him? Was this an accident? Was this a misunderstanding? And oh no,
Yeah.
oh no,
Yeah.
this was no
Yeah.
misunderstanding.
And yet does it again. He's now found with more sexually abusive
Yeah.
child pornography, and charged again. I say allegedly, right? She's
I'll give you
charged again.
my admonishment. Okay. Um, Roughly 1 in 40 adult men is a pedophile. Um, it's not, you know, unprecedented that we have a firefighter as a pedophile. My comment is you either have a pedophile, you have had a pedophile, or you will have a pedophile on your department. And the question is whether or not you're prepared, is your discipline system prepared to deal with that?
Yep.
So,
Yep. Yeah. My department had it. So hell, we had a raid. They took our servers, took everything.
oh, jeez.
Oh yeah. So I,
Were
I
you the
well,
chief then, or
no, thank
no?
God. I was just a lieutenant, but I'm sure it's in your database somewhere.
Okay.
Anyway, let's go to, okay, first of all, kudos to the attorney who's representing this former fire chief. So I was going to summarize very quickly the facts because
Yeah.
the issue, right? So, okay, we have a chief, now former chief, who was, let's say, terminated without due process, right? No hearing, nothing. And his employer says, well, you're just because we have a policy on it, and you don't have a contract, you're just an at-will employee. You can be terminated for any reason without due process, etc., which usually is a stand-up argument, but something you and I probably have never thought of. The
I never
attorney
thought
comes
of it.
out,
And I
right?
think about this stuff a lot, and I had never thought of it.
I, this is big. So everybody listen up if you think you're at will. The International Fire Code, which many states adopt, I think New
Mhm.
York State has, and we use it. We use the appendixes of it. We use it a lot. The International Fire Code has a statement in there that fire code officials shall not be removed from office except for cause and after full opportunity to be heard on specific and relevant charges. And the court says, not so fast. Maybe he is, in fact, a, for cause only terminable person. Now, I think this was meant to apply to the fire marshal
Yeah.
who, when they're doing their job, they may piss off some people. So I could see, right, how the IFC says, listen, we're going to protect the person from, because he goes and shuts down the mayor's best friend's nightclub or
Mhm.
something. We're going to protect those people so they can do their
Well,
job without fear of
but
retribution.
I think the fire chief is also in a position because, living through this in a city where there's a lot of politics, um, it would often be the fire marshal and the fire chief that get called down to the mayor's office. And how come my buddy isn't
And we kind
isn't
of
getting the
saw that in
permit? How come?
FDNY.
Right. Well, because both the fire chief and the fire marshal can find themselves being called on the carpet
Yep.
over political ramifications of their legitimate decisions.
And
So,
this protects them. So
yeah.
here the question is whether the city adopted it.
Mhm.
So maybe you should have read it before you adopted it. And yes, it is like reading paint, right? I mean, it is boring and dry about how many sprinklers and how many alarms and how
Well,
many exit
as a
doors.
former employee of the NFPA, I commiserate. No, it is. But the International Fire Code is written by the ICC. The NFPA has their own version of the fire code, and I'm not sure. I didn't stop to look at the
I'm
NFPA's, but
curious.
they're very similar in terms of their wording and their dryness. So I understand that part of it. But the court did point out that the city went through the fire code and they took out certain parts of it, but they left this one in. They left
Looks
the
deliberate.
yeah, the just cause part in there.
And
So
I don't know whether it would matter if they didn't take anything out of it, but it definitely matters that they did. Shows they went through and right just didn't blindly adopt it. They maybe with one eye. They
well, those have been through my discipline class. No, one of the most boring parts of the class is the due process, hour and a half or so of due process. And we talk about like how can someone go from at will to just cause? And so we look at state statutes. Oklahoma has a statute, but we look at local regulations. Okay. Well, this is one of those types of laws that can then elevate somebody from being at will up to having a property interest in their employment.
Yeah.
So, yeah.
Yeah, and a due process. I don't know. I never find it boring because it's most of my
You're a
clients'
lawyer.
world.
You
Oh,
are
well,
a
that's true.
lawyer.
But people screw it up so badly. Like when I in the volunteer side, when I review bylaws, their discipline sections like this big. I'm like, no. I mean, it needs to be like pages, and people don't get it. Oh, we just assume you're guilty.
Firefighters, it's tough. I lecture sometimes to police officers and firefighters, and we start talking about due process to firefighters. It's like trying to keep their eyes open. I got to do a dance and tell a joke or whatever to keep them interested. The
Yeah.
police officers are able to kind of keep their attention much better,
Hmm.
so. I don't
Okay.
know, but at any
I don't know.
rate,
But that is
it's
groundbreaking.
it's a tough, yeah. This is really an important decision, and for the folks, we're primarily talking about jurisdictions where firefighters don't have much protection. So North Carolina, South Carolina, Alabama, those types of states. Before somebody can be terminated, you're gonna take a look at this. You look at state law. You look at local charters, you look at local regulations, you look at if there's collective bargaining, you look there, you look at fire department rules. In some states, you got nothing. Well, now you got another area to look at, uh,
Yeah.
which is the fire code.
Yeah. And again, I just thought that was such a brilliant find.
Yeah,
I don't know whether the
I gotta
chief
reach out
came
to the
up, but
attorney. The
yeah.
attorney really deserves an award.
If it was
Maybe
his idea, maybe it was the fire chief who came up with it, right? Who knows?
I, I just wonder, like you and I are firefighters, so we're attuned to certain things, but to just walk into a law office and have the attorney say, okay, let me look into it, let me research it a little bit, and
Yeah,
for him to come up with this, I
right.
mean, maybe the client did come up with it, but
I don't know. Whoever it was is brilliant. You
they
get three
deserve.
Curt Vrone gold stars.
We'll give them, yeah, legal eagle award. We got to come up with a coin or something. So,
Right.
but,
That's awesome.
so.
Well, that's it. That's it for this week.
Yeah, that's it for this week. Now, next week, I am going to be driving. Not looking forward to it. Driving to Ohio, I got a class out there, and I've got some other things I got to do while I'm out there. So, I don't know if we'll stop. Maybe I'll stop. Maybe I'll pull over on the way at 1 o'clock,
Or
and
we could
and
do it
we'll
early.
we'll do
Either
it
way.
from the road. So we'll figure it out. So, but that'll do it for another.